Luis, do you want to speak about situation in Latin America?
Yeah, well, particularly in Mexico, where we work, I think this is particularly what Cadito is mentioning, a problem in Mexico. There's very creative interpretations and very inconsistent jurisdictional decisions. For example, and now let me tell you a little bit about the story. First, what the authorities wanted was everyone to register their SIM cards and their phone numbers. And they created this huge database of information in which only half of the users, there was a deadline for people to register, and supposedly if you don't register after the deadline, you would lose your communications. Obviously, telcos freaked out because only 50% of their consumers registered, and they didn't want to lose 50% of their other consumers. So eventually, the government backed down and said, okay, well, we're not going to deactivate everyone's phone. But the database stayed there. The database is available in the black market, in the internet. Not even, you have to like be very shady about it. And they said, okay, yeah, it failed. We invested all this money in a database that was never used, that got leaked, but we're going to do something different with data retention. We'll make companies retain all this metadata, and we'll give warrantless access. So there's been some judicial decisions by Supreme Court, particularly, that are not consistent. On one part, one decision is that metadata is also protected in the same way as content of communications. In Mexico, you have a constitutional right to protection of your communications, and that you need a judicial federal warrant. That's what it said. So there's one decision by the Supreme Court that says that. But there's some loopholes that have been created by the same Supreme Court or by other laws. And for example, one of the metadata that is retained is, for example, location data of phone number. It was first 12 months, and now it's 24 months of every subscriber. It's a massive. I mean, there's no exceptions. Everyone's metadata is getting retained for 2 years, including the location data of the phone, historical location data. And in theory, based on the first decision of the Supreme Court, you would think that you would need a judicial warrant to get access to that location data. And some authorities, we know they do, but that's not the only problem. The other problem is that we don't know which authorities think that they have authority. And you ask telcos in Mexico, and they get requests by the Army or the Navy or authorities that don't really have a basis in law to request this. And some telcos, they comply, sometimes they don't comply, and it's very shady about why and when they do that, because normally if they give access to information, no one will know. They just gave it to the Army, and the only people who know are the Army and the telco, and that's it. So that's a problem. But the other thing, and the worst thing, is that the same Supreme Court that said that you have to have a judicial warrant to get access to metadata has also said that when you want to get location, you want to track a phone in real time, that is location data in real time to the future, then you don't need a warrant, which is strange because it's the same data. I mean, you need a warrant to get historical location data, but you don't need a warrant to get real-time data, which is, it doesn't make sense. It doesn't make sense. And the reasons and it will really end with this, the reasons why the Supreme Court have given in public, because the hearings by the Supreme Court are transmitted in TV, in a channel that no one sees but me, and the arguments is, it's because the data is, you're not tracking a person, you're tracking a phone, and the phone doesn't have rights. And that's literally what they have said, for example. And they have become even more creative in the way that there was a decision in which there were two courts having different opinion, and then the Supreme Court decided who was right. What happens when the police comes and finds a phone in the scene of crime. Some judges were saying you don't need a warrant to get access to that phone because you don't know who that phone is, and some were saying you do need a warrant. The court said initially that you do need a warrant, the Supreme Court, but now there's a new law that tries to overrule that, and we'll see how that's going. Us in our organization is challenging many of these laws. In the coming weeks, we're probably going to have a decision on the telecommunications law. We're fighting against data retention itself, trying to emulate the decision of the European Court of Justice. But also we are worried about the lack of safeguards, the lack of clarity about who can access data. Do they need a warrant? What other safeguards there are, transparency, independent supervision, the right to notification, all these things that are missing, that are just, that the law is very vague, and when the law is vague, then there's arbitrarity and abuse. You know? And I just want to, this is really the last thing that's really important, that this is not, in the case of Mexico and many countries in the global south, this is not just this bourgeois luxury right that I don't want the government to know if I went to Starbucks. No, this is a life or death decision, especially in countries such as Mexico, in which in many cases the distinction between the authorities and organized crime is non-existent. So this debate about security versus privacy takes a different dimension in countries such as Mexico, in which if you give powers, unfettered powers to the government, you are probably, or in some cases at least, giving those powers to organized crime to use against society. So in the case of Mexico, and I think the case of everyone, but just in this context, privacy and anonymity is security, not the other way around.
Okay, well, you just